Hello, welcome everybody to the Tech Legal Trends video and podcast. Since 2019, this initiative has brought together a lot of experts to discuss the latest trends and challenges in tech industry. I'm Thiago Sombra, I'm one of the partners of our technology practice here in our firm, and in this edition, we'll talk a little bit and we'll analyze the main challenges of the technology companies and from a different perspectives. I have today with me my partners Luiz Felipe and Machado from our tax and antitrust practices, and they'll have the chance to discuss with us the most relevant challenges that we may face in the next years. Michele, let's start with you. Let me ask you a question that, from my perspective, would be very interesting for our clients. What are the main challenges faced by companies in the digital market from an antitrust standpoint?
Thiago, thank you for this question. It is a hot topic not only in Brazil, but in all jurisdictions around the globe. And this is so because online platforms, in particular online platforms, holding a dominance position are being targets of investigations not only in Brazil but by antitrust authorities around the world due to commercial practices and also new business models that they are implementing. Everything that I'm going to say from now on is applicable to online platforms holding a dominant position. What is dominant position? It is, according to the Brazilian competition law, a company that holds 20% market share, but this is what we call the rebuttable presumption, in the sense that the company may show that it does not hold a dominant position, it does not have market power, even though they hold a market share of 20% or more. The law also says that even if you have a market share lower than 20%, you can be a dominant company in the market. But in this case, CADE will take into consideration other qualitative factors such as whether this company can be considered a gatekeeper for accessing a market, that it's important for a given market for the players to compete, and also the degree upon which a company may have power to raise prices or implement conditions in the market. This does not mean that online platforms holding dominant positions cannot have commercial practices such as loyalty discounts, exclusivity arrangements, loyal programs, rebates. This just means that they must be more careful while they are, structuring, planning, and implementing such practices in order to be compliant with the Brazilian competition law. What are the main conducts that are targeted by the Brazilian competition law right now? One of them is self-preferencing, which means that any action that may favor the platform's own products or services over the competitor's products. The tier of harm here is, the main concern here is that the company, the online platform may prevent that competitors expand their activities in the market by favoring its products over the products of their competitors. One of the conducts that it is on the spotlight before CADE is exclusivity arrangements, not only in the digital markets but also in the traditional markets. Exclusive arrangements are on a daily basis executed by companies. They means that they will prevent by enter into exclusivity arrangement with another company. You will be prevented of buying products or selling products or having business with certain players or competitors of the company with which you are executing the exclusivity arrangement, which is the main concern here. The concern is what we called in the antitrust jargon as being market foreclosure, which means that this will prevent the competitors to have access to relevant suppliers or relevant clients, and therefore this may ended up in competitors exiting the market. Loyalty discounts are price reductions that they have. It's also a target of some CADE's investigations, and is a price reduction that is granted under the condition that the customer is going to buy a certain percentage of its needs from the supplier. The concern here is also with market foreclosure, but also with raising the rivals' costs, meaning demanding that the rivals should grant similar discounts or even higher discounts in order to compete for customers. Time is also a conduct on the spotlight, and it's a jargon antitrust for a commercial practice in which the supplier imposes as a condition to sell one product that the customer also buy other product. And the concern here is that the supplier has a dominant position in one of the markets, the tying product, and they are trying to leverage its position to the tied product, to the product that they are coercing the customer to buy. And the concern here is also in raising the rivals' costs, especially in the tied product, because they would have to need, the same conditions of offering the same package. So they would need to be active not only in the downstream market, but also in the upstream market.
Michele, as far as I'm understanding here, CADE is having a very complexity and a deep and a close analysis of the market and the tech industry. So we can see that from a variety of perspectives, we are seeing very deep investigations against tech companies, right?
Right. And you are going to ask me, well, how CADE learns about such commercial practice that are being implemented by online platforms with dominant positions? Well, trade associations, competitors, customers, suppliers, they file complaints before CADE, and if CADE sees that there is enough evidence to launch a formal probe, they launch a formal probe, and these complainants, competitors, customers, and suppliers, trade associations, they are very active throughout all the investigations. And we are seeing very, not only deep investigations, but also the increase of a very restrictive measure, which is the interim measures. In recent years, CADE has been granting interim measures which means that they impose restrictions on the commercial practices, or they decide that they will the investigated company must cease its practice until they issue a final decision on the merits of the investigation, and they do so when they find credible evidence that there is potential for harm to competition, and also a risk of irreparable damages to competition if the interim measures is not granted immediately. And what we've seen, there are many investigations ongoing. The ones that have already ended through settlements, And to settle this type of conducts within the antitrust jargon, we called unilateral conducts because are conducts that are implemented by only one company. They do not require, according to the law, the payment of a fine, like in cartel cases. In order to settle, we need to pay a fine. But in these cases, in the past, CAD used not to require a fine in order to settle, but now we are seeing this imposition of fines in some of the cases. And we are also seeing tailor-made solutions in order to settle in this type of cases. And they are challenged because they not only require that the settlement proponent sees a behavior, but sometimes they also involve the investigated company engaging in a certain behavior. They not only need to stop, for instance, engaging in exclusive arrangements, but they need to do exclusive arrangements in a certain way.
Very interesting to see even those kind of interim measures, most of all based on the fact that traditionally we are all talking about fines.
Yes.
And it's interesting here you explaining that we have other measures, alternative measures that are being taken against those companies.
Luis, yes, my question to you is, what are the main tax challenges to tech companies in Brazil nowadays?
Well, Brazil is very complex, right? As you understand, Brazil is very complex when it comes to taxes. And I would say that many tech companies, they're not the only ones facing many issues related to tax. So one of these many, when it comes to international tax, main challenges are very much the challenge that other companies face also. One of them is companies that have operating transactions with the US, with the United States. They now face a very complex discussion as to whether or not they will be able to take a foreign tax credit in US. So let's say if you have a service or a royalty that you have to pay abroad, in general, you withhold the tax in Brazil, and US allows you withhold the tax here, and US allows the credit in US, so you offset the credit and pay just the difference there. What happens is that US is now, since I think the beginning of this year, 2022, US doesn't allow the tax credit in US from transactions from Brazil, which means that whatever you pay here is not creditable in US. That means that you pay double tax. You pay tax here and you pay tax there. And that's a real issue. Because what US says is that you don't have, as Brazil, you don't have the ability, you don't have the nature of the tax of the income as much as you have in US. So we have different natures, and that's why you're not allowing the credit. Brazil doesn't have that much to do because it's US restricting the credit here, there. But what is very much on the table is a pressure for Brazil to change the Brazilian tax rules and for accession to the OECD. And this is something that we have, it's on the table at this point, and it's a homework for us. And yes, companies in US, they are trying to make the tax authorities there change their view in that respect, and we hope that will change soon. And of course, that is something that is provoking some type of tax restructurings in transactions with the US, the use of tax treaties, and then we go to different discussions. If you go to tax treaties, to use tax treaties to other countries, you go to discussions as to treaty shoppings that we don't have at this point. We don't have a tax treaty with the US, which is a sin also. It's a problem for us, and that's something that is again on the table for next years. So this is a real problem for companies dealing with the US. Another discussion that is very much an issue is, again, accession from Brazilian accession to the OECD. That means that we have homework here, which is the change of a new drafting of the transfer pricing legislation, the Brazilian transfer pricing legislation. And that's something that the government has been studying. They said that they would bring a draft in last July. never brought it. They said August, then never brought it. So we are not expecting that a new draft will come to the companies, but we don't have anything at this point. But the idea here is to change the Brazilian transfer pricing legislation, and Brazilian transfer pricing legislation is nothing but legislation that would avoid the disguised distribution of profits abroad, either for the remittance of more cash than you should do, or the charge of less cash than what you should do between related companies. And for tech companies, the real sin here is that whatever you pay abroad, and Brazil is very much a country that pays more technology than what it exports. So we import more than we export, and that's why it's very important for tech companies. And for tech companies, the payment of technology abroad is not in transfer pricing legislation. It's something different, and it's been like that since 1996. And the changes that we had over the years, they never affected that. But the problem is that the new legislation would include the payment of technology abroad to in tech companies to transfer pricing legislation. And this is something that we're expecting that will happen. That would be, of course, that would bring extra complexity to the legislation, but that would bring us to the level of the world, because the OECD standards that they would allow, they would impose that. And that is something that will bring some more challenges for us, because again, the tax authorities, they don't have the OECD and the transfer pricing rules in the US. They say that you go to the tax authorities and then you discuss your prices when you pay abroad or when you receive from abroad. You discuss that in advance with the tax authorities. In Brazil, we don't have that rule, the APA rule. That means that you just do what you have to do, and then you are assessed by the tax authorities. You are just you receive a notice of infraction, and then you take everything to the courts. And that's a bad thing, because the courts, they don't understand anything about taxes, not with that type of a complexity. So the problem there, the new technology, the new transfer pricing rule, all these rules, they try to bring to reduce the liabilities, to reduce the litigation in courts. But on the other hand, they will bring more complexity, because you would bring the need from the tax authorities and taxpayers in Brazil sit on the table, around a table, and discuss these things beforehand, after then bringing that to courts. And that's, again, it's good news, but it's a little bit of more complexity that we don't have at this point. And this is something that will be a true challenge for tech companies, again, because Brazilian tax rules, transfer pricing rules at this point, they're very much focused on tangible issues, very much on goods, exports and imports. When you bring the tech companies to the world of transfer pricing, you bring intangibles again to this. And intangibles, again, they're invisible, they're less, they're harder to measure. So having tax authorities and taxpayers around the table discussing such a complex issue will bring some difficulty to the process. But again, it will be much better to have that around the table than bringing that to the courts, which is something that judges won't be able to understand. And this is going to even though it's really hard, it will be less hard for us in a future transfer pricing rule. So I guess when it comes to taxes, these are the two main issues that we see at this point: the foreign tax rule in the US, specifically with the US, and transfer pricing, again, with all countries in the world, but very much affecting tech companies in Brazil. Again, we don't know when it's going to come into validation by the Congress, but the expectation is that until the end of this year, which is around the corner, we'll have something.
Yeah, it seems to me, Felipe, listen to you, that this is more a Brazilian problem than a problem of other countries. And especially after the acceptance of Brazil and the OECD, most of those problems can be addressed, especially when we have similarity in between tax legislation from all the members of the OECD. So indeed, it seems to me that we have in the near future, a very interesting solution for bringing more investments from the tech industry to the country. I'm thinking here in data centers, for example, or something like that probably could be benefited from this more similarities in between tax legislation in order to possibility discredit in other countries, right?
Yeah, there are two things that are important from what you said. First of all, Brazil is a very big country with a very huge market, so we cannot be ignored around the world. So yes, we have to have investment will always come to Brazil at a certain point, but the flow could be higher or lower. They will have to bring, of course, because they cannot ignore the market. But one task that we have is to make it easier for the investment to come and to attract it more. So this is something. The other thing is, we don't have, we will never have all the countries in the world with the same tax legislation. It's of course it's not something that will be possible because each country has its own reality. But what we want is to have the standards similar to the OECD countries, Europe, US. So if we have the standards, at least we have a framework that is similar to that, at least we can relate to other things. And so the tax credits will be easier to grant, and we'll talk different language, but in a similar standard. So that's going to be, of course, make it easier for the investments to come to Brazil again, much easier in that respect. But what about you? What are the trends in the tech investigation area for tech companies?
Well, I'm a little bit frustrated because I would like to talk about the complexity of Brazil, but speaking after a tax lawyer, it's almost impossible to reach this complexity here. But I will do my best. So we have several investigations. Brazil is probably one of the countries in the world that we have more investigations related to the tech industry. I'll just highlight two that are making us very busy here in our tech and compliance team, which are geolocation. So we do have cases related to providing geolocation data, which means we have several court orders here in the country request specific data related to geolocation in order to identify an individual or criminal, to have more evidences of a crime or something like that. I can give you an example. We are walking here through Avenida Paulista, and a court requests us all the geolocation data related to mobiles that are walking from 11 a.m. until 2 p.m. in order to try to identify which cell phone, which mobile is the individual that practiced a crime or something like that, or a drug dealer or a criminal organization or something like that. So this is something that is becoming really critical, especially from a civil rights perspective, most of all because policy authorities are not anymore requesting specific data, not looking for investigations from a more close perspective, and judges are embracing this perspective, and they are not trying to ground their decisions in even more informations that would be crossed with this geolocation data. So this is something really sensitive, most of all because all of us could be part of a criminal investigation just because we were walking through blocks here in Avenida Paulista in the meantime that a crime was being practiced. And the second one deals with our labor activities. We are seeing a lot of labor courts requesting geolocation data, especially during the pandemic, in order to identify if an employee was at home working or in other places, in order to decide whether or not to pay extra hours for these individuals. So we are working very closely with our labor practice here, most of all to try to understand if in a civil case, just as a labor case, this would be something acceptable. A labor judge requesting geolocation information about a mobile, related to a mobile, just to check if Michelle was at home, if she was in another place where she should be at the time that she said she was working. This is very interesting because the Supreme Court very recently ruled a case related to a murder in which a guy was arrested based on the fact that his mobile was inside a car, but his mobile was stolen by someone, and the individual left the mobile inside a vehicle of a third party with no connection with this guy. So we are trying to address that the mobile does not mean where the mobile is does not mean that this individual was not working, was not the mobile or even the device, a laptop or something like that, is not related to the time that he's or she was working or not, or dedicating its time to the company in a specific situation. So these are the two cases that we are seeing a lot of enforcement from authorities, especially because geolocation is, from all standpoints, one of the most relevant data that we are seeing in the next years.
And how lawful is that to use this
Yeah,
to investigate that?
some courts are considering unlawful because this is not for criminal purposes, and this is protected by our secrecy law for criminal purposes. So even only criminal judges would be allowed, in the purposes of a criminal investigation, to request this kind of data, and also allow them to receive wiretap information. In the meanwhile, someone was at Avenida Paulista or at our office or in other places. So most of the courts are considering unlawful evidence that this individual was not working or was doing another thing and was not related to his work. But again, let's see what's happened. There is a case at the Supreme Court as well, in order to check if this kind of information could be used for different purposes other than a criminal investigation. The third one deals with the MLAT, which is the Multilateral Cooperation Agreement. This is a kind of agreement that allows the exchange of information in between authorities in other countries. Tech industry is facing a lot of problems here, most of all because they host data in other countries and not in Brazil. But when we have a criminal investigation, judges request all kind of data that is available in the country, and they said, no, we don't have the data. Our data is hosted in US, Singapore, China, and other countries. So when a judge requests this information, they said, listen, you have to request this through MLAT for a central authority in the other country, and the judge of the other country will execute this order against us. So this is how it happens in the transnational cross-border cooperation for criminal purposes. But again, this is not being followed by most of the judges in the country. They are requesting directly this information here because they want to get the individuals that are involved in criminal practices. This is before the Supreme Court as well. We don't know yet the final position, but it is very likely that the court decides that the MLAT is constitutional, so the international cooperation proceedings will be in place, will have to be followed. But when a company has a subsidiary in the country, this subsidiary must provide data here in the country and not through the MLAT and not through requesting information to the other countries. And finally, we have children. Especially on the social media, we have a lot of children, teenagers that having access to videos and recording videos for online platforms. And there is a lot of enforcement against videos and social media activities that may influence negatively children in order to consume our products or to eat unhealthy food or to expand misbehavior in the social web and social media. So a lot of enforcement, especially from consumer protection authorities, they are requesting a lot of takedown of those kind of videos without court order. And this is possibly one of the cases that we may have in the future before Supreme Court, if an administrative authority may request a takedown of a video based only in the fact that they believe this would harm children, elderly people, or teenagers without having a court order. This is something that we are saying that the companies are not obliged to comply with this kind of requests, especially because the Constitution guarantees the monopoly of the judicial branch to issue this kind of requests. So I would highlight these 4 topics. Okay, so guys, I would like to thank you so much for this opportunity to have this conversation. I think we reached at the end of our episode here. I I would like to thank Luiz Felipe, Michele. It was a great pleasure for me join you in this conversation today. Well, and I would like to thank our listeners and our viewers. And remember, you have all the possibility to access all the information, all the materials of the tech legal trends at Único, which is our news and legal analysis portal. And also, I do advise you to try to have a closer look in our series, Intellectual Property and the Metaverse. This is a guide that we prepared here looking for the future. And thanks again. The address of our portal is mattosfilho.com.br. You can have the possibility to check it in English or in Portuguese. And also follow us in our social media. Thank you so much.